Good morning, everyone. Welcome to the January 20th meeting of the Virginia Gas and Oil Board. Start out this morning by welcoming everyone and everyone in the room. If you have a cell phone, if you'll please silence your cell phones. The proceedings are being recorded. If you take a call, please leave the room. Take that out in the hallway. For those of you who are joining us virtually today online, if you will remain on mute unless you're participating in a item on the agenda today. And also when you're engaged with the board, if you will engage your video also, so that we'll know who we're speaking with. I'll start out this morning by having the board members present today. Go ahead and introduce yourselves, beginning with Mr. Owens.
Patrick Owens, public member, and Mr. Chairman, I need to declare a conflict, items 5 through 10, due to a business relationship with my company and an interested party.
Dennis Sutherland, Coal Representative.
My name is Gus Jansen. I'm a public member and also serve as the chairman of the board.
Mary Gibson, public member.
Willie Cochran, the Virginia Energy Union.
We also have some board members who are attending virtually today. This time we'll address item number 1. The board will review and approve the remote attendance resolution for any board member that is attending the meeting remotely. First, we have remote attendance request from Lawton Mullins, who is out of town today. So do I have a motion from the board to allow Mr. Mullins to participate in today's hearing?
Motion.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Mr. Mullins, you're online with us.
Yes, Lawton
Go ahead and
Mullins,
introduce yourself. Yeah.
gas industry representative. Mr. Chairman, I also will be abstaining from items 5 through 10 on today's docket due to relationship with my company and the interested parties.
Thank you, Mr. Mullins. We also have a request from Mr. Bill Harris, who is also attending virtually today due to a medical condition. Mr. Harris, you on the line with us?
I am, but I'm not. Can you all hear me?
We can hear you. Do you have video?
Oh, okay, yes. You know, again, I hate to say this, but I'm an Apple user. Every time I've tried to use the Zoom that you all have used, it's never come up. But if I can find it, I'll do that.
Okay. So at this time, we'll need a.
Let me just introduce. I'm Bill Harris. I'm Bill Harris, a public member.
Okay. We'll go ahead and have a motion to allow Mr. Harris to participate in today's proceedings.
Motion.
Do we have a second?
Second.
We have a motion and a second. All those in favor say aye.
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 Any opposed? Okay. Mr. Harris, you're approved to participate in today's hearings.
Thank you. Yeah. I'm trying to find the video. I'll be there in a minute.
Okay, thank you. The next item on today's
Just go
agenda.
ahead. Yeah.
The next item on today's agenda is the board will review and approve the readoption of the board's electronic meeting policy. I believe we also have Ms. Jessica Cooper, representing AG's office, on the line with us today. If she can sort of walk us through this process, would be appreciated.
Yes, good morning, everyone. Hope you're all doing well. So you all should have received the existing board's electronic meeting policy a few weeks ago via email. Hopefully you all have that in front of you or have access to it at this point. This is the electronic meeting policy that the board approved last year and has been using ever since. The terms and conditions outlined in this policy are all derived from FOIA codes and regulations, as well as regulations governing public boards in Virginia. So there's not a lot of wiggle room on this, but if anyone has any specific questions, I'm happy to answer them. Otherwise, this is the same policy as last year, so same rules would apply.
Thank you, Ms. Cooper. Do we have any questions from the board concerning the policy? Do you
I'll
have
make
any
a motion to
discussion?
approve.
Okay. Okay, we have a motion to approve policy. Do we have a second?
Second.
We have a motion and a second. We'll go ahead and poll the board. This one, Ms. Gilmer.
Mr. Owens?
Yes.
Mr. Sutherland?
Yes.
Mrs. Gibson?
Yes.
Mr. Cochran?
Yes.
Mr. Harris?
Yes,
Mr. Mullins?
Yes.
Mr. Jansen?
Yes. Okay, the next item on the agenda is the board will receive public comments. Do we have any public comments requested today? Or do we have anyone in the audience today who wishes to make a public comment or anyone online? Hearing none, we'll move on to the next item. Item number 4 on the agenda is the First Bank and Trust Company escrow agent for the Virginia Gas and Oil Board will appear to address the board on the quarterly year-end report. Ms. Manning, are you with us this morning?
I am by phone.
Okay, thank you, Ms. Manning. You want to go ahead
Everyone's
and, good, thank you. You want to go ahead and walk us through, your report? We'll go from there.
I can't. I assume everybody has a copy of it already. So the first 2 pages are the agenda. We'll start out on page 3. So this is our 4th quarter report. So as of the end of the year, 2025. So our beginning balance for 4th quarter, we started out with $4,554,305.41. We received deposits for the quarter of $44,294.78. Interest earned, which includes money market and CDARS interest, $17,376.61. We deducted fees of $4,583.35. We had a couple of distributions for the quarter. They were small this quarter, $32.13, leaving us an ending balance as of 12/31/2025, $4,611,361.32. On the next page, page 4, we've processed 5 treasury dockets that totaled $120,238.96 for the year, 24 regular dockets totaling $492,099.58. We've issued over 400 checks. They range from 1 penny to $62,291.92. Of those 400 checks, over 200 of those were less than $100. Page 5, this is our outstanding checks. As you'll remember, we were given the authority to escheat checks that were over a year old. So our outstanding checklist is very short now. We have a total of $7,444.76. And some of these have been issued earlier in the year. There is one for 2024 that will be escheated early this year. And then the remainder of them, a lot of them were in May, April and May. So if any of the gas companies have any contact with these people, I'm happy to reissue checks if they can locate these people. Page 6, this is our balance sheet. So this is all of the accounts that are opened. Each individual account, their well number, beginning balance, money market interest, CD interest, fees deducted, any distributions taken from those accounts, any transfers to the No W-9 spreadsheet, and then an ending balance for each unit. And that's just for the month of December. So that takes us through page 14 is the end of that report. Page 15 is a small list of people that have not submitted a W-9. And if you'll notice, 3 of the 4 names that are listed on there are deceased. So I know the gas companies are working to locate their heirs. And then once they have all of their heirs, we can release the funds. So we have $902.03 sitting in the No W-9 account. Page 16 is annual distributions. So this is all of the income that we've received since First Bank and Trust began as escrow agent in 2010. All the distributions that have been paid out each year. And then the graph on the side. Page 17 is the investment of funds as of the end of the year. So you have a little over $2 million in a money market account and then $2.5 million in brokered CDs. And there's a couple of those that are coming due, but they don't come due until April. So we have April and July and October of 2026. And then page 18 is the rate comparisons for Cedars rates, Treasury rates, and our DTC, which is our brokered CD rates. And then the last page of the report is the CD rate ranges. So we have 3, 6, 9, 12, 18 months, and then 2 years as far as the ranges. Does anybody have any questions?
Any questions from the board members? On the funds that are coming due in April, if I'm assuming we have a March hearing, you won't be back until the April hearing, is that correct?
Correct. I will be back at the
This
April
quarter.
one.
Do we need to do something before that meeting for you to handle those, or will they just go into the money market and then we can reapply it to a CD in April? That's fine.
They will go into the money market account. Do we have an April date on the calendar yet? They may not mature until
Yeah, it looks
the April meeting.
probably around the same time. I mean, it'll be the third Tuesday, which will be sometime around the 20th of the month, I would guess.
So these will be coming due right about that time.
So,
So we can make a decision at that time as to what the board wants to do.
21st is the date.
if everybody's
But we
fine.
still
with
have
it,
sitting in
Yeah.
the money market account.
Yeah. We don't need to do anything today and let the board members feel like we need to. So we'll just let those stay where they are. We'll address that in the April hearing.
Okay.
Anything else, Ms. Meany?
That's all that I have today.
Thank you very much. Again, thank you very much for all the work First Bank and Trust does with our escrow accounts. Continue to do an excellent job maintaining everything for us. Thank you.
Well, have a good day.
Here we have, before we move on to the next docket items, I think we have three motions provided by Diversified that we need to address before we move forward. All the parties, and I think those involved, both Pocahontas Gas and we have some responses to that if we want to have Diversified come forward, and we'll make some motions before we move forward on the hearing.
Before we start, Mr. Chairman, I just wanted to let you know that I did not receive Diversified's motion to continue. It must have kicked back in the email because it was so large. So I'm still in the process of downloading that, and it has been downloading for over an hour. I haven't been able to review this yet. So if before we get to that motion to continue, I'd respectfully request that the board take a brief recess and have Ms. Gilmer pull it up on the screen so I can read it before we get into the substance of it, so I can adequately advise you all.
Okay, thank you. First motion that we'll take under consideration today is the Diversified's motion to dismiss petition ruling of unit E36. I believe we have a submittal by Mr. Street, and we've had responses probably back and forth, at least a couple. I've lost count. So if you want to briefly walk us through your petition for this motion, Mr. Street, then we'll have Mr. Schwartz do his response, and we'll have some discussion.
Yes, sir. Good morning to the board, please, the board. We are here today on 4 drilling units. The motion to dismiss is on one of those. It's unit E36. That's a unit where Pocahontas Gas has filed an application to pool. And in its application, they have alleged and therefore conceded that that unit, E36, is 100% owned by Buchanan Energy LLC. And 100% of the coal bed methane gas in that unit has been leased to our client, Diversified Production. So you have a unit which is can everybody see that if I leave it right here? I can let you hold it. I also have smallers if you'd like to, but so here's the unit right here, E36. And this color here, which I'm calling pink, is the fee ownership of the unit. And that is Buchanan Energy. They own everything in the unit. They own the coal, mineral, the gas, the surface, the timber, the salt, the water. They own it all. They entered into a lease with the predecessor to Diversified, leasing all of the coal bed methane gas to Diversified. So we have 100%. It has been by statute and by the practice of the board, and even by the testimony, the prior testimony from CNX and Pocahontas Gas, that when you own 100% or when you control it through a lease, it is voluntarily pooled. And that's what that unit is. It is voluntarily pooled in favor of our client Diversified. In fact, we have a well, existing coal bed methane gas well on that right now. And we or our predecessors have had that well in place for over 10 years. Because of that, this board just doesn't have jurisdiction to come in and pool that unit. And that's by statute. There is Virginia Code Section 65.2, 1620, I believe, sets forth the 3 conditions that you have to have before an applicant can pool a unit. And going to pass out to the board a copy of 65.2, 1620. It's a field. So we're looking at Virginia Code Section 45.2, 1620, and that's the pooling statute. And subsection A of that gives the board the authority to pool, to involuntarily pool gas under the 3 different scenarios. The first of those is A1, where 2 or more separately owned tracts are embraced in a drilling unit. That condition is not satisfied in this application by Pocahontas Gas because there is only one owner in the 80-acre unit at issue in E36. So you can put an X over A1. That doesn't apply. A2, there are separately owned interests in all or part of such drilling unit, and those owners having interests have not agreed to pool. So that's important language there. Those owners having interests have not agreed to pool their interests. Well, there are two there are two entities that have interest in E36. One is Buchanan Energy as the owner and lessor of the coal bed methane gas. The other owner is our client, Diversified, as the lessee of the coal bed methane gas. So you do have two separately owned interests in the gas leasehold, but the important language there is before you can invoke the condition A2 to pool, those two interest holders, those owners, cannot have agreed to pool and voluntarily pool their gas already. And so in this situation, we Diversified have a lease with Buchanan Energy. And that lease gives Diversified the right and the obligation to produce gas. That is a pooling agreement. And so under A2, I want to emphasize that the Virginia legislature has, through the inclusion of that last phrase, those owners having interest have not agreed to pool. That's an important precondition that is not satisfied here. And the inverse meaning of that is if you do have a pooling, if all the owners in the unit have pooled, this board, it doesn't have jurisdiction to force pool it. And the applicant in this case, which is Pocahontas Gas, doesn't have standing to file the application in the first place. So as to number two, that condition is not satisfied either. The third one just doesn't apply. They're separately owned tracts embraced within a minimum statewide spacing requirement. So under 45.21620, none of the preconditions are satisfied. And I would submit to the board that that's consistent with what your practice has always been. I don't think there's an example of where you force pooled a unit over the objection of the 100% owner. And this is why. So that's the motion to dismiss. Of course, I know the motion for continuance is being reviewed, and we'll get to that in a minute. But in a response, we filed that motion to dismiss prior to November. This past week, we filed a brief or a memorandum fleshing it out some. Yesterday, for the first time, we received, it might have been yesterday or the day before, but I think it was yesterday, Pocahontas Gas provided a new alleged basis for pooling a unit that has 100% ownership, which has already been voluntarily pooled, and a unit that already has a gas well. And in the opposition statements that the parties respectfully filed previously, that allegation and that basis was not disclosed, nor was it disclosed in the original pooling application. And so as a result of that, no one has gotten notice of that. When we get to the motion for continuance, this is another basis for the continuance. The board presumably has not considered an independent jurisdictional basis for pooling under Virginia Code Section 45.2/1622. I showed you 20. Pocahontas Gas, as of yesterday for the first time, is now saying we're not proceeding under Code Section 45.2/1620. We're proceeding under 1622. The board will be in a better position to answer this than me, but my assumption is the board's never addressed that issue. We did not have any indication after we filed our motion to dismiss 2 or 3 months ago that was an allegation. It was not disclosed in Pocahontas's opposition. And that is a novel argument that we disagree with, by the way. But we would add that as an additional basis for our motion to continue so that not just we, but the board also can be apprised of that, consider that, and prepare for that argument further. But turning to the merits of that argument, I know Mr. Swartz will speak to it. I showed you 1620. They're going to talk about 1622. So I'll pass that out as well. The board will recognize this statute because it comes into play where you have a unit and owners of the gas estate disagree about who owns the gas. So you may have a 30-acre tract and there are competing owners. One owner alleges I own the coal bed methane gas. Another owner disagrees with that and disputes that and claims to own it. And in that condition, y'all are going to know far more about this. I mean, I lived through this time period, but for a long time you had trouble with these disputed ownership claims. And so a process developed whereby you could continue to pool, would just escrow the royalty that would be payable to those disputed ownership claims. That's what this statute is. It does not provide an independent pooling jurisdictional basis. It's actually an add-on provision, and within the code section itself, it references 1620 and simply says where you have disputed ownership of the gas estate, we're gonna ask you to do some additional things, and that is 1622 subsection B as in Ben. You have to establish an escrow account. Subsection B3, escrow account, escrow account, escrow account, and I've highlighted those provisions for you. 1622 is just, that statute just says where people dispute who actually owns the interest in a unit, we're going to use an escrow. That's what that says. And when you look at the language, it makes that clear because this, in the very first subsection 1622A, it says if there are conflicting claims to the ownership of the coal bed methane gas from any claimant, and that term is important in this analysis, claimant, because claimant is a defined term in the code. Claimant is defined in 445.2 1600, and I'm going to read you the relevant language here. It's a person who is identified as possessing an interest in production royalties by virtue of owning an interest in the gas estate. The claimant is someone who alleges a possessory interest in production royalties because and by virtue of being owning an interest in the gas estate. Well, this board knows that it does not, and it avoids doing this actually. It cannot transfer ownership interest in property. Ever since I've been involved in work before this board, the board has always taken great pains to say, we don't rule on who owns what, and we don't convey interest in real estate. So as to E36, there is no way that Pocahontas Gas can be a claimant and own an interest in the gas estate in E36 by virtue of being an owner, because they're not, and they've conceded that. What they are trying to argue doesn't make any sense. They're saying because they have pooled a unit in an adjacent panel of coal that may drain gas from E36, they want you to equate that to ownership of gas in E36. And we all know you can't do that. There is only one owner of gas in E36, and that's Buchanan Energy, and diversified through its lessee interest. Why are they using 1622 in this new way that's never been used before and doesn't make a whole lot of sense with statutory language? It's because under 1620, they know they can't pool it. And that they can't pool it again because we have already voluntarily pooled it. And that precondition is simply not satisfied under 1620. So that's the position. Of course, a lot of that's in the brief as well, which we would incorporate in our position. If you have any questions, I'd be happy to answer them.
Have questions, or want to hear from Mr. Swartz before we start questioning? Any other questions now? Okay, Mr. Swartz, you go ahead and on.
Okay, thank you. First of all, I think I need to point out that Diversified really has never filed a motion to dismiss. They say in their, they filed a memo the other day, but find that. They say that this Diversified Productions memorandum in support of motion to dismiss. And I went looking for a motion to dismiss and didn't find one. And in fact, they acknowledge in their memorandum in support of the alleged motion to dismiss that what they're referring to is a notice of opposition that they filed back in October. Now, if they filed a motion to dismiss in October, I would have responded, but they didn't. In fact, they've never filed a motion to dismiss. They filed a notice of opposition. Well, I mean, they were telling us they were opposed to our application, and I wasn't required to file a response to that, and I didn't. When I got the memorandum in support of a motion to dismiss the other day, I think it was Friday, I thought, well, I went looking for the motion, couldn't find one, but I thought it would be prudent to respond, and I filed a brief response to the motion to dismiss. I'd like to show you, if I could, I'm going to try to display this on my Can you see this map of the E row and F row? Is that showing up?
Not at this time. We'll take a minute, but.
Okay. Kelly, can you perhaps pull that map up? I'm not real great at this.
Now we have it.
Okay, Kelly, actually the map I want to see is the one with the acreages. There we go. Can you make it a little bit bigger? Great. We're talking about unit E36, and you've got a partial outline of E36 off to the left, and you'll see there's a block of solid coal by the mains and the entries in the corner. And next to that block of solid coal, you'll see the number 1.05. The E36 has 1.05 acres in the 19 East panel. Okay. The 19 East panel includes, F37, 38, 39, 40, F36 as well. It includes a small piece of the southern boundary of E37, 38, 39, and 40. So essentially what we're talking about here at the moment is Diversified is telling us that they have a claim, or they have, I guess, an opportunity maybe to drill a well, a gob well in that 1.05 acre piece, and they're going to extract gas from that. And if they're not telling us that they're going to drill a well in that 1.05 acre tract, they're saying essentially that by refusing, our petition, they don't want to receive gas from this panel. And I think, you can talk to Mr. Skarupa about this, but the fact that you have entries and mains in close proximity to that tiny tract makes it highly unlikely that the operator of E36 would ever be able to drill a well there or to get a well permit. The other issue is, and we have witnesses as we get into these pooling applications, but Coronado provides locations in the panels where they propose that gob gas wells be drilled. And Coronado has not, well, they've finished determining where they want wells in the F row or in the F row and in 19 East. And Coronado is not proposing any wells in the E unit, or for that matter, the E36 unit or the F36 unit. So there are wells that are gob gas wells that are going to be in F37, 38, 39, and 40 that are producing gas from the 19 East panel. And also they are draining the 1.05 acres that's in the E36 unit. The operator, and at this point, the operator of F37 and F38 is Pocahontas Gas because of pooling orders that have been entered. Pocahontas Gas is also the operator of F39 and F40 because those are voluntary units in which we are going to drill gob gas wells. So 4 out of the 5 units in the F row and 4 out of and the same situation applies. Well, in the E row, we have voluntary units in E39 and 40, and we're here today on 37, 38, and 36. But the problem with the approach that Diversified is taking here is they are saying they're going to, they want to be the operator on a voluntary basis, I guess, of a unit to produce coal bed methane gas, gob gas, from, I guess, 19 East when they can't drill a well there. Coronado hasn't proposed a well there. In fact, the Coronado gob gas wells that are proposed are all in other units. They are clearly going to drain that one acre tract. They're going to produce gas from there. So the operator of, which in this case is Pocahontas, of all the other units in the F row that will have gob gas wells in them is required by both the Oakwood 2 field rules and by the pooling orders that this board entered with regard to F37 and F38 to pay royalty to Buchanan for gas pertaining to that 1 acre tract. And the reason, or a reason, that we are moving to pool E36 is because we have that obligation to pay them. If Diversified wants to participate in the 19 East panel, they'll have an opportunity to participate, just like they'll have an opportunity to participate in the other applications we have today. But the argument here, when they're saying they were creating a voluntary unit, they can't produce gob gas from that 1 acre. It's being produced by gob wells that are located in other units in the panel. And it's just, and I can't even, how can you create a voluntary unit to produce gob gas when you can't produce it? You can't have a well, I guess is my question. So if you could take that down temporarily, Kelly. Okay. Let me address also. Mr. Street says that you need to be a gas owner to pool? Well, if you look at the panel, the 19 panel, there are a ton of people who own interests in the gas coming from that panel. And Pocahontas Gas actually owns gas. I mean, it has royalty interests in units E39, E40, F39, and F40. So Pocahontas Gas will actually receive royalty from gas produced from the 19 East panel because it's a royalty owner in 4 of those units. In addition, Pocahontas Gas has working interests in F37, F30, or assuming they've applied for petitions there, but they currently have working interests in 40, F40, F39, E39, and E40. So they've got both working interests already established in that panel, and they have royalty interests. So I guess if you took, I don't think 1620 really applies here, but you know, if you take what Mr. Street is saying, Pocahontas Gas actually is a royalty owner, owns gas in 4 of the units affected by the 19 East panel. So on his theory, we could come in, I guess, under 1620. My point is there are 2 completely different approaches comparing 1620 and 1622. The provision that I believe applies here is the 1622 provision in the code. And it's really simple. I mean, it starts by saying if there are conflicting claims to the ownership of coal bed methane gas, the board, upon application from any claimant, not owner, claimant. Well, there are tons of claimants to this gas. Everybody who owns a royalty interest affected by acreage in 19 East is a claimant. And if by some miracle somebody drilled a well in that 1 acre tract, there would be claims to over 90% of the volume produced from that well. I mean, to put it bluntly, if somebody were to drill a well in that 1 acre piece, a gob well of E36, over 99% of the gas that came out of that well would belong to other people. That's how small that interest is. And that 99% would pertain to both working interest claims against the 99% and royalty claims. The statute that we are claiming under is actually entitled Pooling of Interest for Coal Bed Methane Wells. That's what 1622 is called. It's not even mentioned in Mr. Street's memorandum. So, in summary, it is essential that we pool E36 for 2 reasons. One, so that we can share revenue from the gob gas wells that we're going to drill in the other 4 F units with the owners of that 1 acre. And on the other hand, if we don't pool that unit for gas from E36, no one has an opportunity to produce that gob gas because you can't drill a well there. And my memorandum is fairly short, and I hope that some of you have had a chance to read it, but essentially, we are attempting to protect Buchanan in spite of their best efforts to run us off, so that they get their share of the production of gob gas from the 19 East panel. So that, in summary, is my opposition to the not filed motion.
Briefly. Mr. Schwartz cited that the title of Virginia Code Section 645.21622. But he left out a very important part of the title of that. He gave you the first part, but not the second. Part he gave you was pooling of interest for CBM wells. But what is important about the title of that statute is the next language: conflicting claims to ownership. That's what the purpose of 1622 is. You have to have conflicting claims to the ownership of the gas in the unit to be pooled. That's E36. You don't get to look around at other units somewhere else and say, well, we have an ownership interest over there, therefore we have an ownership interest in E36. In fact, they don't. Pocahontas Gas does not have an ownership interest in E36. And Mr. Schwartz was careful not to say that they did, because that would be incorrect. They don't have an ownership interest in E36. One thing he said, which I agree with, is the pivotal issue under 1622 is, are you a claimant? Mr. Schwartz says there are all kinds of claimants all over. They're all throughout panel 19. That's not true, because the word claimant has a specific statutory definition that makes that a false statement. To be a claimant, it's limited. To be a claimant under Virginia Code 45.21600, you have to identify as someone having an interest in royalties because you own an interest in the gas estate within the drilling unit to be pooled. Does Pocahontas have an interest in the gas estate within E36? That's the question. I've got it. And the answer is no. And there is, Mr. Schwartz doesn't allege otherwise. They concede that they do not own any gas interest in E36. If they have pooled it, but it's on appeal, as you know, some units in E30 in the 19 panel under the Oakwood 2 order, if that order withstands de novo scrutiny for the circuit court, they will be sending a check to us by virtue of whatever interest is in E36. That's okay. That's all they need. Let me suggest to you why that they really want to pull this unit. Because this is the unit, E36. This is this little red square here is what they say matters to them. But if they're successful that they pull this entire unit to protect Buchanan Energy, they will in effect then be the operator of the entire 80 units. So when panel 20 gets produced, this is the one well 20, they're going to have the right to the whole thing. And there will be wells that drill to produce gob gas on panel 20. This is just plant a little flag right here, and then they get to operate the whole thing. That's not allowed by the statute. That's just not allowed. They don't make the requisite show because they don't own any gas in E36, and the statute's clear. We have voluntarily pulled E36. We do intend to drill gob wells in E36. And I submit to you statutorily, we're the only ones that can do that. And I would argue that's what Buchanan Energy wants. I would suggest to you, as you probably already know from prior hearings, they don't think Pocahontas Gas is going to protect them very well in that unit. But we won't get into all that. But that's the response.
Yeah, the first thing I think we need to consider here, and I'll ask Ms. Cooper to weigh in on this, is Mr. Swartz claimed that there has been no motion to dismiss E36. Do we think we have a valid motion that the board can act on today, or is there something that needs to occur for remedy there?
I've not been able to locate one in my email. Miss Gilmer, if you could double check your files, I would be appreciative because I've got a lot of them over here and just want another set of eyes.
While she's looking, I can help her find that. Early in the case, we filed called opposition statements, and on the E36 opposition statement, within the body of that opposition, we asked for it to be dismissed forthright and immediately based on these grounds, both in the body of that document and also in the prayer section. But to the extent someone doesn't think that was a motion to dismiss, we'll make one right now in addition, and that should cure that problem. There's no requirement as to when you move to dismiss an application. So I think it's a moot issue, but
Mr. Chairman, on behalf of Buchanan Energy, we have filed a motion to dismiss. We do adopt Mr. Street's in total, including his rebuttal. That motion to dismiss is in our objection on a jurisdictional basis.
one other thing too. To the extent part of the argument is that you don't have jurisdiction to do this, you can't waive jurisdictional arguments. So whether we could not make a motion at all, which I submit we've done twice now, but it would still be a legitimate issue that you would have to reach since it goes to your jurisdiction.
Does that help you, Ms. Cooper, or do you still need to say
Yes.
something else?
I'm still checking on the oppositional documents, but since it was renewed orally, I do think that the point is moot, unless Mr. Schwartz would like to make additional argument on, perhaps his ability to research the issues in advance or something like that. But at this point, I think it's moot.
Anything else, Mr. Schwartz?
Well, I guess,
We can have
I guess.
further discussion. I didn't want to get into more discussion and we can have questions.
Well, right. The reason I indicated that no quote unquote motion had ever been filed. If they had called their opposition a motion to dismiss, I would have responded to it. Okay. They didn't. They called it an opposition, which is kind of here's where we're coming from pleading. And I just wanted to respond, I guess, to Mr. Street's argument that I never responded to their motion. Well, in my view, they didn't make one. Okay, that was the whole point of that. I don't want to add anything beyond that, Mr. Chairman.
Okay, thank you. Question from the board on this issue.
I have a question for Mr. Street.
Yes, ma'am.
What are your projections to drill in that particular little area?
Right. The drilling in that area is going to be at least 3 years down the road. So for that reason, it's my understanding Coronado hasn't designated specific locations yet, but everything we've been told, there are going to be 3 gob wells in that.
So you're saying 3 years down the road, you'll consider drilling? Is that what you're?
Yeah, what's going to happen is as Coronado's mine works move to the north, they will be mining these longwall panels. They're not projecting to reach this will help you. Question. So again, we're talking about E36 right there. And if you look at, see this column of MineWorks? I'm just going to tell you this for reference purposes. E36 right at the top of those. This is the Coronado mine projection map. So remember, it's top of this column. So you're talking this area. This gives dates. So for this longwall panel, Coronado says they're going to start this at this end, February 1st of 2029. And they're going to go this direction. And they're going to get up here February 25th, 2030. So you're still 3 years out from starting that. So, but the best projection is they're going to put 3 God wells in that unit right there. Does that answer your question?
The other one, the other one she liked.
Oh, sorry.
It's on everything.
Leave this here for John McKinney.
I guess I'd like to respond to the board member's question. I think Mr. Street just told you that there is no plan to drill in that 1 acre tract. I mean, he didn't say that in so many words, but I think that's the gist of what he just said. The other important thing he said is that there is no plan to drill for at least 3 years. Our information is it may even be longer than 3 years. So, and then I would observe that if you pool a unit and get a pooling order from the board and you don't do anything for 2 years, it goes away. So, you know, we need to address production from that 1 acre tract now, not 4 years from now. There will be testimony later today as we go on, whether or not we go on with 36 with regard to some of these other units, that nobody knows what the 20 row is going to look like yet, because there are there's consideration that the 20 row would start further to the east and begin in some additional coal that CNX and its affiliates own. There is the work to build the mains around 20 is delayed. We'll have some testimony with regard to that. So we're at least 3, maybe 4 years away from drilling gob wells in 20. And we are already outlining and starting to isolate the 19 panel, which is going to be isolated within a year. And we need to address how are we going to distribute revenue from that 19 row, which includes this 1 acre tract.
So if drilling is delayed for 3 years in that area, then that's going to affect your projections or what you plan to do.
Well, we're going to be producing from the 19 panel, which is, it's going to be produced within the next year. Okay. The 20 panel is the one to the north, which is at least 3 years out. So our production is going to occur in, sort of the immediate future, and it's going to affect that 1 acre tract, and we need to be able to pay those people.
Okay, thank you.
Thank you.
Mr. Schwartz, in part of your written response that was provided to the board, you made mention that the Oakwood Field rules had originally considered generating these longwall units that weren't tied to these 80-acre units. Because I think the
Correct.
fundamental point here is these 80-acre units are what are creating this issue today. If you didn't have this 80-acre units, you could come in here and generate a unit around your long wall and move forward the pooling and bring it in another interest without the issue of ownership and operatorship. So where we're sort of stuck here, and I think everybody understands this, is that this unit, and Mr. Streets pointed it out, if we grant Pocahontas Gas operatorship of E36, we're granting the whole unit. We're not granting just the 1 acre part of it. We're granting the entire unit going forward. Is that
For
correct?
Oakwood 2, and they would still have their Oakwood 1, yes.
And so the implications to that, I think Mr. Street hasn't specifically said it, but are great if they want to become an operator in the future panels.
Well, they obviously are going to have if you were to two answers. If you were to pool this unit, okay, they would have an opportunity, diversified with the offer an opportunity to participate in the working interest with regard to gas coming in because of that 1 acre. Okay.
I understand that. I think
Okay,
Diversified's
and then-
position, and I'll speak for Diversified here, I think their position is they want to be the operator. They do not want to be a participating operator. They want to be the operator.
I understand. Let
On
me,
the future.
if I could
So there are
finish. Okay, if we come back here in a year or 2 years or 3 years, when we know what the 20 panel is going to look like, okay? We will have to modify this order at that point in time to include the 20 panel. And at that point in time, if Pocahontas is the operator, Diversified will have the opportunity to participate. And I understand they want to be the operator, but they will have the opportunity to participate, and they will have the same working interest in the 20 panel that they would have if they were the operator. I don't see that the dollars and cents to Diversified change because they're going to have an opportunity to participate in the working interest. The only thing that you point out is they want to be the operator. But from a dollars and cents standpoint, they're going to have a chance to participate to the full extent of their interest under the Buchanan lease in the 1 acre tract and in the E20 to the north, which obviously is going to be more substantial.
Okay, we understand that. Let's go back
Okay.
to the field rules that you put in there. Your comments on that, that the originally when Oakwood 2 field rules, that you made some comment to the fact that there was some attempts. I don't know. I wasn't familiar with the attempts that may have been done early on to just generate units that did not tie to the 8 acre units. Can you,
Yes, I can. What happened, and I'm thinking this must have been early 91, 92. Pocahontas Gas, at that point was not my client. And they didn't retain me until after they bought Oxy out. But in the early 90s, Pocahontas Gas came to the board and proposed to create long wall panels. And Benny Wampler was the chairman at that time, and they actually allowed that, and they created long wall panels, kind of like the sealed GOB units that we have now. So you outlined a long wall panel. I can't remember if it included the entries or mains to some extent. I think it may have, but in any event, they created long wall panels, and they exempted those panels, if I remember correctly, from the Oakwood 80 acres. So they were standalone, excuse me for 1 second. Got some other things going on. And they experimented that for maybe, there were a number of those units. Certainly maybe 15, 20 of those units. And they decided ultimately to not do that. They stopped granting or creating long wall units, and they instead adopted the Oakwood 2 rules, which is kind of like a hybrid unit. They don't call it a unit, it doesn't really create a unit, but it requires you to share production and royalty and working interests over a panel, but it doesn't really create a unit. It retains the 80-acre units as sort of your base royalty revenue paying operation. So yeah, they did that for a while, and I think that the problem with that approach was it was carving up 80-acre units in ways that were difficult to contend with. Whereas what we have now is, if you have production, frac well production, you can have an operator producing frac wells in a unit. And if you have gob gas production, you can have an operator producing gob gas, because the mapping's the same. And I think that's ultimately why they went with, Oakwood 2 instead of creating longwall units. Now, this is a long time ago, Mr. Chairman, but I think.
You don't really know the reason why we changed, or why it was changed.
Yes.
And I don't know if that's documented anywhere. Staff know if it's documented anywhere with the Oakwood 2 field rules.
Well,
Chairman, there are old records of what Mr. Swartz spoke of, some of the panels. There are a few of those that were out there before the Oakwood 2 field rules.
Before the Oakwood 2 field rules.
Yeah, some of the panels. There were some of the panels that were
they just were unitized on their own.
Yes, sir.
And but we still carve out, when we do our calculations, we still carve out only portions of the 80-acre units, correct? Because it's all tied back. We don't use the entire acreage of the 80-acre unit to calculate somebody's ownership. We only use whatever part of their ownership's within the panel. We still carving it out.
Correct. And that was true, when we had panels, and it's true now. Yes. And there were, I've seen some of those. I think some of those panels, you'd have to ask Mr. Scroop to check. I'm not sure he would know off the top of his head, but I think I've seen indications that some of those old, long wall panels are still producing, and are still active, I think, or were until fairly recently. But obviously when the Oakwood Field Rules 2 was the sort of the solution to the problems that the board saw with creating the long wall panels.
So we have some things going on with the Oakwood 2 field rules. And back to the field rules, do you have an opinion on whether the field rules address unit operatorship? And can you have multiple unit operators within a unit specifically?
Well, I think you can have
by the definition.
If your question is, can you have one operator in a unit that is operating a frac well and another?
We're limited to Oakwood 2 under the gob gas.
Okay, I guess you could, in theory, have an operator for each panel. Is that what you're asking me?
Or within the panel, within an individual panel. In other words, if Diversified becomes the operator of this 1 acre, they would be an operator within this panel, correct? If they are successful in pooling that unit.
Well, the problem with that idea, though, is they can't be an operator with regard to 19 because they're not going to have a well. And that's my problem conceptually with this. If you don't have a producing gob well in the panel, how can you be an operator? Okay.
Agreed.
Yeah,
I don't think it allows for that. I don't think it contemplated competing operators. Can we agree to that? And we don't think the field rules.
Correct. In a panel, certainly. Absolutely. Absolutely.
Yeah.
It didn't contemplate having more than one operator operating wells producing from a panel.
Or from any other unitized. I don't think the regulations or any of the field rules out there contemplate dual operators in any unit. Is that fair?
Yeah, except we've got
Except under
we've got
different rules, under different
Yeah.
field rules.
right, but we actually have situations where we've got more than one operator, one under Oak 1 and one under Oak 2 in the same units. I mean, we got 3 or 4 of those already that we've had, which makes sense. I mean, to take E36 here, I mean, Diversified has inherited a frac well, which is going to be in the way of mining in E20. Okay. And presumably they're going to continue to produce that for 3 or 4 years until they have to deal with, what's going to happen with regard to the mining. And that's not going to interfere with, Pocahontas operating, so they can pay that little tiny piece of that tiny 1 acre. So
Let's go to another hypothetical.
Okay.
In the 19 East panel, we haven't started production of any gob gas to date, correct? Is there
I'm sorry.
anything, there's no gob gas production to date, correct? It hasn't begun. Longwall's not begun, correct?
The production has not begun in 19 yet.
So is there anything that will prevent Diversified from filing a petition in front of this board to create a unit for the entire panel that is not subject to the Oakwood 2 rules for production of gas? Do we think the Oakwood 2 rules supersede anything that you can do going forward?
You would have to modify the Oakwood 2 rules to allow what you're suggesting. I mean, we basically have 3 kinds of production that's recognized by the board at this point. You've got frac wells under Oak 1. You've got gob gas wells and, underground, short hole, long hole. But gob gas wells under Oak 2. And then you've got sealed gob units, which is a standalone. I mean, there are no field rules with that, but with regard to that, but the board has created sealed gob units. So those are the 3 kinds of production that you currently have. These are not going to be.
Does that preclude you from filing a completely different pooling application for a unit that covers the same acreage that is not currently, that they have standing in on part of that acreage, to be the operator of that unit that would be conflicting with this methodology we're using here today? Do you think that Oakwood 2 prevents that?
I think Oakwood 2 prevents that, but you would have to modify the Oakwood 2 order to allow people to do that. Because, Oakwood 2 is a comprehensive, it applies to several 100,000 acres, right?
I agree.
And if you're going to do something different, if you're going to produce gob gas.
So that's where we're at today. We've got something that wasn't contemplated by the Oakwood 2 rules. 2 operators wanting to produce the same area.
Want to produce gob gas from the same area,
Mr. Chairman,
is what you're saying.
I'm looking at the Oakwood 2 order, and I'm not so sure what I agree with what you just said. I think the Oakwood 2 order does contemplate different operators within a panel. Within a panel.
Okay.
Yeah. So this is page 6 of Oakwood 2. It says, when there are 2 or more separately owned tracts or undivided interests separately owned within an 80-acre drilling unit established hereby. So that's not a panel, that's a unit. So when they're, then the owners thereof may validly pool their interest and develop the drilling unit as a unit. So it's talking in terms of each individual unit, not the panel as a whole. So it certainly contemplates, as we have here, this panel 19. Diversified leases.
19 is down here.
What'd you say, sir?
19 is the shorter one.
Yeah, I'm sorry, 20.
That's sweet.
I'm sorry, I misspoke. On 20, Diversified owns 100% of that one, 100% of E35, and 100% of E36. And I'm not certain, but I think Pocahontas Gas may have 100% of E39. So you have 1, 2, 3, 4, 5, 6, 7 drilling units within that panel. 3 of them are completely owned by one party or controlled by one party, and then it's completely controlled by the other. According to the language of Oakwood 2, you look at each one of those units separately. And it says within an 80-acre drilling unit established hereby, the owners, so that's true here, the owners of this one may validly pool their interests and develop the drilling unit as a unit. Same would be true over here. If that's Pocahontas Gas's unit, they may do that for their unit. It goes on to say, however, where, however, such owners have not agreed to pool their interests, that's not true. But I'll tell you what it says if that were the case. And if they have not agreed to pool their interests and develop the drilling unit as a unit, then upon application to the board, their rights and equities may be pooled. So I would commit to you, sir, that on page 6, subsection J, the Oakwood 2 order does specifically answer your question. And that is, even though it's a panel, you still look at it as a unit by unit by unit basis. And so for this unit, for the owners of that unit have pool, that's against them. That has the benefit of being fair as well. Since my client has invested in all of this property, they ought to be able to their units. And then if Pocahontas Gas is invested in this unit, it seems fair that they should do that as well. That's, if you like, I've marked it all up, but you're welcome to see it coming.
So in that logic, the longwall panel is irrelevant, other than just for calculating payment.
You're right, that's right. Now, there is a procedure, and it's 65.2, 1619, where there is a statute that allows an applicant to modify the drilling units. So no one has done that in this case. Pocahontas Gas could file an application with the board to modify the drilling units in this area so that the drilling unit is no longer this unit that encompasses the complete panel. If that were to happen, and by statute, there's a different list of factors and considerations that the board would need to consider. Different, I mean, from simply the straight up pool. But there's a process for that. No one has done that, which means you're looking at this on a unit by basis.
The problem with all of this is the E36 unit, whoever's the operator of that unit, really has no opportunity to produce gob gas from the 19 East panel from a well located in that unit. So you got an operator who's not producing gas. And that's the problem.
That's one of the implications of dismissing.
Uh-oh.
I'm sorry.
We just lost your visual. Hang on just a second. You're still there. Okay.
Okay.
You're back.
The problem with this particular unit is if Diversified or somebody else is the operator, well, frankly, the operator of E36 standing alone, because there will not be a gob gas well located in E36 that drains the 19 East panel. You've got an operator who has no production or revenue to share. And we're trying to pool E36 because we have 2 voluntary units and two forced pool units that will be producing active gob gas from that panel that we want to share with that acre in E36. I mean, that's the problem. You know, if you say, well, we voluntarily pooled the unit, my response is, well, where's your well that you're going to produce gob gas from pertaining to 19? And there isn't going to be one. I mean, that's the, focused on this particular unit, that's the problem.
And I think that's the underlying problem is that you got to look at the implications moving forward on what happens to this unit. If you've denied somebody some rights going forward to be the operator in the rest of that unit.
Well, I'm going to have, we're going to have to come, we're not seeking, if you look at our application for E36, we are not addressing the 20 East panel, Mr. Chairman. So we're going to have to come back when Coronado knows what they're going to do with that panel, and we're going to have to petition this board to modify the pooling order to include the 20 panel. And there's no reason why at that point in time, Diversified can't come in and move to modify the order so that they can operate in the 20 panel. We're not trying, if we were trying to push them out of 20, we would be seeking to pool this unit with regard to production from 20, and we're not. We have no division of interest for the 20 panel. If we're going to produce gas from that panel, we're going to have to come back here, or Diversified, can come back and modify this order. So the idea that we're somehow preventing somebody from vindicating their rights with regard to the 20 panel, when and if that is produced, and when and if, Coronado knows what they're going to do there, that's not true. All we're seeking by our pooling application at this point is to deal with that 1 acre in that one panel.
That's not necessarily stated in your order though, is it? Correct?
Well, it's
the order.
Well, we can't, it is and it isn't. I mean, we cannot produce, let's assume the 20 panel was done and we were going to try to produce gas from that and share it. We would have to come back to you to approve the division of interest and to force pool the people, no, we can, it's not in our order, but we're not being granted. If you enter our order, you're not giving us permission to do the 20 panel. I guess is the best way of saying that. If you enter our order, you're giving us permission to pay revenues with regard to the 19 panel. And that's it, because that's the only thing we've addressed. We've set forth Buchanan's interest from 2 tracts that total that acre in the 19 panel, and that's it. There's nothing in our proposed order about the 20 panel.
If that's what they're proposing, does it make sense for us just to do a voluntary pool between Diversified and Pocahontas Gas as to their units in 19 to let them pay us? I mean, if they're willing to agree to that, we're willing to accept their check. And that way we don't then bind everyone up on E36, because we all know what that's going to look like later when we come in and say, wait a minute, we'd like to back up and rethink this. It's not going to, but if they're willing, if that's all they're asking for, and if my client is willing to receive and accept that payment, then isn't that the way to pursue? Is just show a voluntary agreement between the 2 parties. And if they're not willing to do that, then that may raise questions about what the real end game is. But
well, we got the wrong person saying that. I mean, but Buchanan needs to say, we'll take your royalty check. Okay. And then Diversified needs to say, we will pay the participation cost associated with that 1 acre, which is negligible. Okay. To have a working interest in that money, or they can say, because I think one of the units that we fooled before, they chose to not participate in at all. They may just say, I mean, is this tiny little piece here, does Diversified really care about that? I don't think they do. I think Buchanan does. So, I mean, between the 2 of them, is Diversified saying we want a working interest in that 1 acre, or are they saying we don't care about that? And then Buchanan can say, but we'll take your check. I mean, what's the response to that? Is Buchanan willing to take the royalty from us? And is Diversified going to waive a working interest in that 1 acre, or do they want to assert their rights?
That's 1 acre. That's right. All right. So the other subject of that.
Yeah.
that's a question to him. What would, Mr. Chairman, do you think that it would make sense to take a 15-minute recess? Let Mr. Pruitt talk to his client about this issue a little bit before he responds on the record.
My client has some questions.
Yeah, we'll take a recess for 15 minutes, let them talk through this. We'll reconvene at 7:45.
Ms. Gilmer, would you please pull up the motion?
Okay, we are back on the record this time. Mr. Davis wants to address the decision.
Mr. Chairman, thank you. And for his board. This is an attractive possibility. I think it would be a good way to untangle this. And if the board would allow, I need to speak to the principals. Is a principals of Buchanan Energy, because it is a decision that has ramifications. And if the board would allow me the time, I think that 3 things in particular stick out to me that you need to look at. The application on E36, I believe, should be withdrawn because it's an 80-acre application. It's not a 1.5-acre application. And I think that would be appropriate part of any agreement. And any payments made for production that's allocated to that very tiny tract should be escrowed, depending upon the decision of the circuit court on our pending appeals, and adjusted accordingly depending on circuit court does. But we escrow it and it's protected fund. And finally, because of the existing appeals, just an agreement similar to one that was reached earlier by these parties, that nothing that is done here by this agreement will in any way affect those appeals, so that neither party points back and says, look, you've already agreed to this, you can't argue. That it just be a standalone separate agreement. And under those parameters, I would be prepared to recommend this solution principle. And I think they would listen.
You have any comments on that, Mr. Schwartz? And you're muted, by the way.
I have a problem with remembering that. Thank you. I think that the proposal that you had made, Mr. Chairman, was that we withdraw the E36 as unnecessary if we could reach an agreement. So I think, that's the point of the exercise. So obviously, this application would go away and that can would be kicked down the road. So that's not an issue. With regard to escrow, I mean, I guess if Buchanan doesn't want to receive the money, we could pay it into escrow, but why wouldn't we just pay them? I mean, they're entitled to the money no matter what. Why can't we just pay them? And with regard to no waiver, I don't see that this is a waiver by anybody of anything.
Sounds though we can tentatively agree on the 3 points. I don't think the escrow hurts anybody if we insist on it. I think it does provide another level of insulation of this agreement from any decision by the circuit court. That would be important to my client. They wouldn't want to jeopardize their appeal by having the court say, well, you've taken the money. So that's the level of protection that I think is needed, and it also allows the court to say, we're going to adjust these payments, we're not going to adjust the payments. Doesn't tie the hands of the court in any way. And it sounds like we're going to be able to agree this will in any manner be raised in the court as any type of defense or supporting argument. So the final thing then, of course, is time to discuss this with the principals.
So, Ms. Cooper, I guess, from what we've heard here so far, from action by the board on Diversified's motion to dismiss, are we basically going to continue it? Is that what we're asking?
Well, we need to know, Mr. Chairman, we need to know what is Diversified's position on this agreement. Are they going to participate? Are they going to waive? What are they going to do on the acre?
I'm in the same position Tom is a little bit. We've got a lot of folks here, but the decision makers for Diversified are not here. But I would recommend something like this to the client if the devil's in the details on all this stuff. But what they have discussed sounds like a good solution to me. I would not have a problem recommending that to the client, but that's not something. It would be impossible to get a written agreement with all the detail in it today. But I think I'm the one that suggested it. So I would definitely recommend something like that to my client.
So back to my question to Ms. Cooper, do we just need to take a vote? Do we need a motion to continue?
Yes.
Do you want to ask for a time frame? Do we want the next hearing? Is that the way we want to approach this? And then at the next hearing, we can either have your agreement and we can officially withdraw the application for E36 at that time.
I would leave this up to the board right here. I don't have a preference. If you want to do, I'm just making some assumptions here, and that is we've got a motion to continue all of them. some of these issues are interrelated. Do we want to do them all at the same time? If we don't get this one piece resolved, seems to me that we would. Do you want to do that at the next regular board meeting, have time on that day, or do you want to do a special setting? If you want to do a special setting, we can do it before that February date, but I'm okay on the February date as well.
Yeah, I think the February date will work. We only have one potential item on the docket for next month. So if we want to just entertain a motion to continue, the motion to discuss.
But Mr. Schwartz, can you hear me, sir?
Yes.
Do we need to, I'm trying to prevent work if we don't have to do it. Are y'all in a position to continue everything until February with the
No.
hopes that we can? Okay,
No.
so we probably need to,
We need to hear the other, we're gonna have to address the other motions that we have before us before we can move forward in that. So, but right now, we're just gonna deal with this one motion to dismiss the petition for E36. Does that make sense?
Well,
Okay.
and I think, to be, so that we're not negotiating all kinds of stuff in the meantime. I mean, I think we need to put on the record that the motion, or that a continuance of the motion to dismiss E36 is so that Buchanan could decide whether or not what Mr. Pruitt has suggested is acceptable to them. And so that Diversified can decide whether or not to participate on some basis or not. And those are the only loose ends. My client is prepared to pay royalty on the 1 acre directly to Buchanan. I don't need to confer with them any further. And is prepared to accept Diversified's decision as to we're going to be participate, we're going to be carried, or we're not going to be involved. So, we're good to go with this. So all we're waiting for is Buchanan's agreement to what their lawyer is recommending, and then Diversified's position on participation. Not a lot of other extraneous stuff. And if that happens, then we will withdraw the E36 petition as unnecessary.
Everybody understands what all the board's action is we're going to continue this next month. You're going to come back and you're going to say, we've reached an agreement. We're withdrawing our motion to dismiss and we're withdrawing the petition.
yeah, but my hope would be long before
You all come to your.
we can tell them yes or no, and we'll know in advance, because if we have.
But we'll still have to address it again.
Yeah.
As a docket item.
Yeah.
We'll have to, we can't, I don't know the time frame it's going to take you and you don't know the time frame. So all we can do is continue it for a month. It's the easiest way for us to deal with it. If you've not reached an agreement, then we'll pick up from here again.
Rule on the motion.
So all I need from the board, if I understand this correctly, Ms. Cooper, is a motion to continue.
Correct.
The motion by Diversified for dismissal of unit E36. Will someone on the board make that motion?
So I get number 5. Not hearing number 5 today.
That is number 5.
Yeah, we can continue, we can make that, we can include that in there, but we can address that separately when we get to it, if we get there. We may not get there. We just, let's address it separately when we get there.
I'll make that motion.
Okay, do I have a second?
Second.
A motion is second. Ms. Gilmore, will you poll the board?
Abstain.
Mr. Sutherland,
Yes.
Mrs. Gibson,
Yes.
Mr. Cochran,
Yes.
Mr. Harris,
Yes.
Mr. Mullins,
Abstain.
Mr. Jansen.
Yes. So we'll continue that item until next meeting scheduled for February. The next motion for the board's consideration is a motion to subpoena by Diversified along with Pocahontas's opposition and supplemental oppositions. We have a lot of paperwork again on another motion. So again, do you want to briefly, since we're at the lunch hour, we want to wait till after lunch. I guess we can do one of the two. You can take a lunch break now, or we can try to get through these two motions and then take a lunch break.
It's up to y'all. I see your lunch out there, but however y'all want to get it, I'm fine. I don't, unless that lunch is for me, I don't have it.
Let's go ahead and see what we want to do with the motion to subpoena, where we stand on it.
Yeah, I think we briefed that pretty comprehensively. I don't want to take up your time just repeating what we've already said, but there is a process, which I guess is a little bit unique to the board, where the language of the statute says that the board shall issue witness subpoenas. Once they're issued, then those people that have been subpoenaed can object and move to quash, and then there would be consideration of that. That's the process. And so I think the next step would have to be the board would issue the subpoenas, and then the parties would be able to object. The two witnesses that were asking to be subpoenaed, they testified at the last set of hearings. So clearly they have relevant probative information that would concern these issues. They're not, I appreciate some of the humor from Mr. Schwartz, although some may not, but they're not really in the same position as the Vice President of the United States, which was in his objection. They're actual witnesses that have been before the board on these things. I think they're both either on the line now or they were. And so I just respectfully don't see what the issue would be with subpoenaing two witnesses to the trial that were here on the last set of trials and testified on similar issues. Mr. Schwartz has responded, but with a letter that said, okay, we'll make them available if you preemptively agree to limit the scope of your questioning. His position can and will be taken up. But there's no tribunal I'm aware of that makes you basically concede to a motion in limine in order to get your witness subpoena. You get the witnesses to the hearing, then there will be questions, some of which you'll probably find relevant, some of which you may not. And I'm sure Mr. Schwartz, as I know him now, will make sure that he objects when he disagrees with those questions, and then you'll have a chance to review the objection in the context of this case and the other evidence before you in the arguments. That's the time to take that up. But given those things, this doesn't seem like a hard issue since we've seen these witnesses before.
Yeah, if I could respond. I filed a supplemental response because Josh Ball I knew was going to testify today because he's our well-cost person and has other information. He is going to be testifying, assuming we don't have a continuance of everything, and he will be available today for Mr. Street to examine or to recall as his own witness. I also offered to have Mr. Green available today, and he has been online. And my caveat was, which I now hear is unacceptable, and I'll pursue that in a moment, but Mr. Green is available. Both of these people are available. They could testify today. If Mr. Street wants to call them as his witnesses today, they're available. The reason that I am accommodating his request is because I want to be done with these cases. I mean, we have been struggling with this since June. If we finish the docket that we have today, I am not going to darken this board's doorway with units involving or with issues involving E20 for another 3 or 4 years. So if we can conclude this today, we're done with this. We'll obviously be handling appeals and stuff, but you're not dealing with that. So I don't want to have you issue subpoenas for people that are available to testify today which is going to cause a further delay. I mean, if you issue a subpoena, it'll have to be served on these people and they won't be testifying today. They're here today. With regard to and my caveat with regard to both witnesses, I was hoping that Mr. Street would say, I understand that the board doesn't want to hear testimony about well cost reimbursement, and they've told us that on multiple occasions. I understand that the board doesn't want to hear testimony about carbon credits or alternative energy credits. Clearly, Mr. Street is not willing to say, I won't get into that. So my response is, these guys are available. If he wants to call them, he can. I will make my objections, and I assume the board will respond to my objections appropriately. So you don't need to issue subpoenas. They're both here.
Is that agreeable to you, Mr. Street? It doesn't sound like he's limiting your cross-examination or examination of these witnesses.
To me, where we are right now is if we're going to continue the case, we probably need subpoenas, but if we're not going to continue the case, they're here. So maybe we need to look at the continuance. But if they're
You're
here,
not
I
go-
can call
Well, you're not going to need subpoenas because I've said I will make them available. So for some reason, you
now.
don't get, for some reason or other, you don't get the question.
Okay, I'm sorry. I misunderstood what you said. If he's going to make them available today or in the future, that's fine. I don't need subpoenas.
So you can withdraw your request.
Yeah, with that representation, I don't need the subpoenas. If he's going to make them available whenever we have the hearing, yeah, we don't need to go to that trouble.
Okay. Is that acceptable, Ms. Cooper, that Diversified withdraws their request for subpoenas?
Yes, sir.
We don't need
Given
to
that
vote or
Mr. Schwartz would make them available.
That's on the
either
record.
today or in the future.
And then we have one final motion. We have a motion by Diversified to continue all the formal hearings due to their FOIA request, along with what they claimed as a notice issue. I want to address that.
Yes, sir. There's, I guess, 3 reasons why I feel like rescheduling of the cases makes sense, maybe 4. I guess 4. Reason number 1 is a lot of this stuff is not going to happen for 3 years, right? So that's 1. Number 2, we filed we actually submitted 3 FOIAs. That's a Freedom of Information Act request under the FOIA statute in Virginia. And we submitted those quite some time ago. We got some responses. But on one particular question, which concerns these cases, I guess the Department of Energy technically basically said we need some time to get those records together, to research, to go through and find responsive documents. And as they're allowed to do by statute, they said this is going to be time consuming and somewhat expensive. So we need y'all to pay us some money for this service. And the price they quoted was a little over $2,000 to do all of that. All of that happened before the November hearing. And so we came before the board in November. The board was aware of the FOIAs, and I think maybe not completely on that basis, but in large part continued these cases until now to give the Department of Energy enough time to gather those records for us to have and review and to get prepared for the hearings. We then cut a check for $2,000 and something, $6, and sent that to the Department of Energy, I think on December 12th, which of course is right before Christmas and New Year's. And they got that, and we filed with you the certified mailing and all. And I don't know what happened, but we still haven't gotten any of the records. I'm not pointing fingers. I'm saying we don't have it. I mean, it's probably a holiday related issue. I just don't know. But in any event, the board or there were, I think appropriately commented at the last hearing that that was something that we needed to be prepared and to try the case. That hasn't changed any. Those, the couple things we asked for. One was copy of records relating to when an operator of a frac well has been allowed to convert the frac well to a gob well with longwall panel mining. And so you can see we have we have 3 wells. This is the case that just got continued. But we have a frac well here and a frac well here, and these are 2 of the units that are at issue today. And of course, our position is, because we already have a frac well, when longwall panel mining comes through, that's what it converted to a gob well. And that was one of our positions in the last set of hearings as well. So we asked in our FOIA request for records related to when the board has done that in the past, when there has been a conversion from the frac well to a gob well with the same operator, and what that process looks like and what those records look like. And so that's what we need. I don't know when we can get it, but as soon as we can get it, do it. We can then use that and be ready. And again, if we can get those records next week, we can do a hearing the week after. It doesn't have to be February, but so that's one basis.
I can address that one. Those records, in my understanding, have been sent today.
Oh, today? Okay. Well, that should give us plenty of time for
15 minutes.
Charity?
11th hour. 11th hour, you can get used to it too.
Well,
And I'll say the records have been sent to our Richmond office. The Richmond office will disperse the information
Okay.
to them. So I do not know if that has been done yet, but I do know that the records have been sent to our FOIA officer.
There were several items on that request, if my understanding. I've seen it. There were 6 or 7 things on there. They've all been addressed other than one, I think.
on that one, there is one other thing we asked for, and that was a map. Do you know the status of that? There was, there's an order in particular, one of your all's older cases. I won't even bother you with the matter number, but it's an older order, and there was a map attached to the order. That's not on your website. So we asked for a copy of that map. If y'all have it. I can give you a copy of that, Sarah.
We got the request and we sent that back up to her back in November. So I'm just looking. Just make sure you.
Has the request. She said she's in.
We'll follow up, Mr. Chairman, on that one. I have to check on it.
What is the relevance of the map? The
The map is attached to one of the 4 orders that we've discussed in prior cases, and it concerns the pooling units and the pool.
Is it the Oakwood 1 or Oakwood 2? Is it one of those?
Well, it's an order that amends Oakwood 1 and Oakwood 2. And it attaches a map that has I haven't seen the map, so I don't know exactly what it says, but I think it shows the location and maybe of drilling units, and I don't know what's on it, so I can't tell you how helpful it might be. I just know that your published order on your website doesn't have that plat of the units, so.
Okay, now I remember. We responded to her and I'm sorry she didn't respond to you about it. The map's located on our website under resource material under the Oakwood file. So, we can help you with that.
Okay.
Maybe just have us go through them. I apologize. It just slows everything down, but.
Yeah.
How
So it sounds like it's on there. It's just not attached to that specific order. It's just maybe an unattached version or something.
It's under the Oakwood file on our website.
Under the Oakwood rules, under the
There's a
head.
file on there that has like the field rules, and then you can click on Oakwood and it's under there.
There's a map that probably is a map showing the Oakwood units. Looks like. Is that probably what it is? And you can open it up and
Sarah, is that the map that extended the Oakwood field to the east?
That's the 0348. It's the
docket.
Yeah.
So the map just added to the existing
yes, that's correct.
that's out there, which is probably irrelevant to the area we're talking about today. Is it, you're saying it went to the east, we're over to the west?
It was an expansion of the Oakwood 1, Oakwood 2 area.
Rules to the east, but not, the area that's under consideration for this hearing is it's already under those rules, right? It's not gonna happen. That's what just trying to. Then the items under the first, the item number 1 was dealing with the records associated with the wells that have been plugged. What's entailed in those records? Just for information in the board.
So we would have on those, if those wells, if there's originally a frac well and it's bottom plugged, basically plugged through the Pocahontas number 3 to allow for mining through those wells. So we research those wells, see what we have on record of those wells that are partially plugged.
So what you provided that he may or may not have yet, it's just a list of wells.
So list the wells and then any associated board orders that we found for any of those units.
Okay.
That those wells were in.
It was a reference to the board orders, but not the actual board orders, or did you attach the board orders?
Yes, and then it's direct them to where those board orders are on the data information system on the website.
Okay. Just wanted to be clear what we were asking for and what hasn't been provided to this point, so. Okay, Mr. Swartz, do you have a response to the
Yeah,
motion?
Just given what they're seeing, they're lacking. I think the map is not relevant to the applications. So, I mean, they can ask for that, but I don't think that map is going, extending the Oakwood field to the east is going to come into, is going to come into evidence at any point in time with regard to these 4 applications. With regard to converting frac wells to gob wells, I mean, I don't see how that's relevant. I mean, you can file an application with the division to rework a well. I mean, but what does that have to do with a pooling application? So I guess, if we're considering continuing these hearings because of requests for information with regard to conversion of frac wells to gob wells, or with regard to the existence of a map extending the field to the east, I don't see how that's going to be relevant evidence on any of these applications. And if that's the 2 reasons for a continuance, we don't need to be continuing.
If I'm not mistaken, all the Pocahontas gas applications that are before you on those 3 units where we have a frac well, I know this is what Pocahontas has said in prior related cases, but they make an allegation in there that specifically says those existing frac wells will be plugged and abandoned. And in doing so, that will render the Oakwood 1 rule, the Oakwood 1 order, it'll nullify, it'll end the effectiveness of it. And that answers the question about whether it's relevant, right? I mean, if their application today or previously has gone to the effort to say, don't worry about the frac well because it's going to be plugged and abandoned with this long wall, and now you don't have to concern yourself with the Oakwood 1 rule order. Well, if that's not, that has to be important, right? That's why it's in the application. So I don't know what the record, hold on just a second. I don't know what the records are going to show, or what those attached orders are going to reveal, or how those cases proceeded or evolved before you. But certainly that issue is relevant. They put it in issue, not, I think in these cases, but certainly in related cases. And we want to be able to understand that process, to know, because the Oakwood, there's an Oakwood order that comes after Oakwood 2 that talks about what happens when you have a prior frac well and then what happens when it becomes a gob well. And we would like to understand better how that order works with these cases that you've seen before, so we can address that, what is clearly a relevant issue. So I don't, to say it's not relevant is unsubstantiable given the way that the applications have been pled.
Okay, so to respond, you're saying that our allegation that these wells are going to be plugged and abandoned is not accurate, because I assume your client is going to testify they're not going to abandon the well. Why do you need records from the department to testify to the fact that that allegation is not accurate and you're not going to abandon the well? Everybody knows you're going to have to plug the well if mining is occurring, and I assume you're not arguing that point. But I gather you're saying we don't plan on abandoning the well. So, your witnesses can testify to that. You're not going to get something from the department saying, addressing the issue of whether or not you're going to abandon the well. So I don't see that that's relevant. You just put a person on the stand who says, these are our plans for that well, and that will be in contention. So I don't see that requesting what other people did with converting wells or not converting wells is going to pertain to your position here. I just don't know why we have to wait for that.
I think before we go, just to clarify, when we talk about abandoning, are we talking about a bottom hole abandonment associated with Pocahontas 3? Are we talking about a total abandonment of the entire well?
Total abandonment. I mean, what the reality is, and I think I need to say this. Most people do not rework frac wells to convert them to gob wells because of the expense associated with it. Okay, so I'm sure that has happened, but it's a decision that Diversified can make, and they can tell us in their testimony what their plan is. What other people have done and records from the department about what other people have done is not relevant here. Are they going to just partially plug the wells? Are they going to completely plug the wells? They need to tell us. Typically, what we do is we plug and abandon the wells and drill a gob well. Okay, that's why we made that allegation.
Mr. Schwartz is objecting to the relevance of documents that I haven't seen. And that's part of the problem. I can't.
No, what other people did is not relevant to what you plan to do. That's what I'm saying.
So if Pocahontas Gas is willing to concede that we have frac wells and that when longwall panel mining comes through, we will be able to convert those over to gob wells that we will operate. If he's willing to concede that, that's what we're going to try to prove. If he's not willing to concede that, then that's an issue. And for us to have a fair chance to prevail on that issue, we would like to be able to know what has been the board's practice in the past, how has that process worked, what's it look like, and that's all we're asking. It's to know what the board does on this issue, this related issue historically, is that's going to be. I mean, you're going to want to know what you did. It's going to mean more to you to know what you've done in the past than to know what our clients think you should. So but again, we won't know until we see it.
Here's the problem with that. This board does not issue well permits. This board doesn't enter orders about well permits. This board doesn't issue orders about recompleting a frac well as a gob well. This board doesn't do that. The division does that. So, when you say that the board needs to know about well completions, well conversions, well permitting. The board doesn't know that. They don't pay any attention to that. They don't issue permits. They don't modify permits. So these records, will show you what the Division of Gas and Oil does, but the board doesn't attend to that when it makes these orders. So again, the practice and procedure with regard to completing or not recompleting a well has nothing to do with pooling a unit.
We're going back and
I
forth.
don't know who makes a decision within the Department of Energy or the division, but whatever that is,
Can,
Whatever those-
let's have the staff address it briefly right now, how that works.
So
Maybe that'll help you.
we permit the well as, if it's a frac well, it's permitted as a co-ed methane well. If it's partially plugged, we get records of that. And that we don't change, there's no other permitting of that well. Any type of how those wells are viewed as far as royalties or anything, that we don't do that as the division. If there's any type of modifications to the permits, that would go through us. But typically, if a well is just bottom plugged and it's continued to produce, there's no modification or anything that we require, any type of modification to that permit or anything.
and then does the same operator company that operated it as a frac well then continue to operate it as a gob well?
It's actually continued to operate just like a frac well. But it's just if you have it plugged, if it's plugged through a certain zone or anything, we have that record. We call it partially plugged well.
Yeah.
And where it falls in the mining operations, we don't,
So
from our
when,
standpoint, we don't, it doesn't matter. to
when the
us.
longwall panel comes through then under a frac well and it's plugged to the surface of the seam, but it continues to produce,
Correct.
it's now producing gob gas, right?
It's actually just, from our standpoint, we don't change anything there as far as any kind of permit. We don't redesignate those. In permitting, it still stays the same as it did. We just have a record that well is plugged through a certain zone. For instance, the ones we're looking at would be through the Pocahontas 3. If the mining came through that well, you're just producing those seams above it. It's still, there's fracture zones above the Pocahontas 3 also. We don't redesignate that as a type of well per se at the department. We don't do that.
And so you don't, there's no way for y'all to figure out whether the operator is then paying under the Oakwood 2 gob formula versus the Oakwood 1 frac formula?
That's correct. We don't do that. The department, we do not do that.
How do you know that it's not gob well gas? If it's gob well gas, wouldn't the operator then have to pay out differently if it's producing from the gob?
If it's the gob well gas, then whatever the Oakwood 2 rules require, then those wells would be paid out under the Oakwood 2 rules.
By the same operator though, right?
Then, yeah, depending on who's operating the well.
And the records that we're getting ready to receive, those will shed some light on this process.
What it'll show you is the units that we have wells on record that's been partially plugged. So it would show you the well, all the wells that we have on record, that we have a record of that well was partially plugged, but it's still producing. It's an active well.
And it will show the same operator continuing to produce even after the gob wells come through.
It'll show you the operator. It'll show you who we have.
So yeah, we think that's really, really key to some of the arguments.
I'm not sure you're understanding that the gob wells are completely separate. They get permitted separately from the original frac wells. Those are permitted as gob wells. They produce as gob wells. They're separate. There was a practice, there used to be a practice where they mined through frac wells, plugged them temporarily, and then reopen them to try to produce a gob gas. Is that correct?
The way that there's different ways, in this area, but in one area. They are wells that are, they're plugged, they're bottom plugged. Since the Pocahontas 3 is the bottom sink, gonna be the bottom producing sink. You plug that well, those wells actually have fiberglass casing in there. You plug with the cement plug up through to above the Pocahontas 3 to that area. So 100 feet, whatever it may be, above the Pocahontas 3 and then if the mining comes through that well, you could actually mine through that well and that well would continue to operate.
As a frac well?
In our records, we do not change.
Unless an operator comes to you and specifically wants to convert a well to a gob well. There is a process for that.
Do that, yeah. Because we've always just, if it's a frac well, it stays.
Is that your question? That you're asking which wells have been converted? Or are you asking which wells are which wells are just associated with mining? Either way, I'm not sure that either one of them are relevant to the proof of that. Because they both fall under whatever the fuel rules were.
Once I look at these records, I can answer your questions better, but
I'm trying to understand what you don't understand about the process.
yeah, well, that's.
You have a whole room full of technical
Join the crowd.
to help you understand that
Yeah.
process. Is that not true?
This is my understanding, okay? And this is our position right now, but when we get the records, it may change. But right now, what we have understood is, and there's an order, and I think I actually talked to Brad about this previously, but one of your orders, which is, docket number, it ends in 349. It talks about what happens when a frac well that is undermined by a longwall panel, what happens when it then produces gob gas. And it produces gob gas whether the division says it's a gob well or not. A gob gas is the gas that percolates up from the gob zone. So it may be producing gob gas, even though you guys don't list it as a gob well or a frac well, it's still producing gob gas. What your order says, as we read it, is once that happens, once it's no longer producing frac gas, but it's now producing gob gas, the operator stays the same, but the operator now has to pay under the Oakwood 2 formula, which is the gob formula. And we're trying by that. We're trying.
What Mr. Street is saying here, is that correct?
We can look that up and see if that's what it says in that.
But in a general purposes though, the frac well continues, just because it gets undermined, the frac well doesn't go away. It's still producing from the other coal seams, correct? Under the frac well.
Yes. Yeah. So it's still producing everything.
So what you're implying is that well is also producing gob gas.
That's what I would like to look at the records to find.
I don't think the records are going to tell you that, is what I'm getting at.
It may be, you may be right. I don't know, but
Because we don't,
They just told you that they don't tell you that.
we don't get into the royalty like from our side. If it's,
Right.
That's what the division, we do not see, I don't see how the royalty payments of any of those wells are distributed out. That's covered under the rules of the board. So I don't, that makes sense. I guess I don't see that part.
Yeah, the well that's within that unit is either governed by the original 80-acre unit under the Oakwood 1 rules, correct? And it stays under the Oakwood rule as long as it's not completely, if it's partially plugged, it stays under the Oakwood 1 rules. Unless an operator files a change to the permit to convert it to a gob well. Which I think that was a practice in the past. It's not been done in a long time, I don't think, right? Is that?
Now, we designate the wells when they're drilled as a gob well for
A new gob well.
those things.
Like the wells that we see, that the board sees as part of the application that are designated as gob wells.
Mhm.
The existing frac wells that are already within the unit are going to continue to produce under the Oakwood one. Even if they're mined through,
Here's what
paid out under the Oakwood one. Is that correct, Mr. Schwartz?
I'm
Here's
sorry,
what your
cut-
order-
you-
Here's what your
you-
order says. It says for gas from any well located in a longwall panel. And the context there is pre-existing wells. After actual commencement of coal operations by the driving of entries and completion of the longwall panel, the amount of gas produced from such well and attributable to each 80-acre unit shall be the ratios. I'll save you the trouble. That's the Oakwood 2 formula. And before in that order, it says, the following, if you back up, says in conjunction with the Oakwood 1 order, establishes a uniform method. Specifically, the board adopts the following method for calculation of production from unsealed gobs. The following method, however, shall not apply to wells producing under the Oakwood 1 order unless and until circumstances contemplated by subparagraph 3 occur. Subparagraph 3 is when the longwall panel comes under after actual commencement, then all of a sudden you transition to the Oakwood 2 formula. That's just the language of your order. We would like to see what the records looked like, to see if we've been following that or if not, and why. I'm not disputing what you say is in it, but we would like to see it so we can, you adopted some of my reasoning today and you did a good job, but I do need to look at it myself to figure out where we are. That's all we're asking. It's just so we could see the records, try to figure out what that means in the context of this order and whether that helps or hurts our case and how I can put that on to benefit my client. That's all I'm asking.
The problem is that you have been
What's provided, does that provide what he's going to need to do that under his FOIA request?
Well, it'll show any wells that we have on record that are, we list them as partially plugged. We do change the designation when a well is partially plugged, so we have those records. We did. That's what we provided, was that list of those wells.
Okay. So
there is, I feel like I'm not taking all the responsibility, but we have been on this, I'm sorry. But there is one other reason for our motion for continuance, and that was for formal hearings, the board has been giving us and is supposed to give us under 2.240, 420, some things prior to the hearing, including the basic law under which the agency contemplates authority and the matters of fact and law asserted by the agency. I'm not going to go over that again. That's in the brief, but that's another basis.
Mr. Schroeder, did you have something to add? Did you have something to add? So again, I'll refer back to Ms. Do you have anything else to add, Mr. Schwartz, to the last point?
I did respond in an email that I sent to Ms. Cooper, and I think it found its way to the board members with regard to the notice issue. The rules for notice for this board are different than other boards. I mean, for example, if you're a doctor and you're licensed to practice medicine is under consideration, the board, makes that decision, not applicants. This board, it's up to the applicants. And if you go to the statute, there is a statute on notice in the Oil and Gas Act, and it requires the applicant to actually give the notice. And there's a list of things that you have to provide in your notice. And we provided our notice. We provided all of the information that we rely on in our application, and you got that from us. I mean, the letter that folks get from the board here is simply a courtesy reminding you this case was continued to such and such a date. So I think that the argument that the board's notice was somehow deficient is just misses the point. We gave a notice. There's never been an objection. I mean, the case came up in October, November, December, now January, and now we're hearing the notice is incorrect and that you gave improper notice. I mean, we gave the notice. We were required to do it. All the board is required to do is publish their agenda. So I think the notice issue is just a red herring.
Thank you, Mr. Schwartz. I know Ms. Cooper has just received this motion today. Do you want to weigh in at all on the motion for the board's
Yes, sir.
information?
If I may, during the recess, I was able to read it. Thank you, Ms. Gilmer, for helping me with that. So in regard to Mr. Street's first point about the basic law under which the agency contemplates exercise of authority, Exhibit E, the second page of it, right above the signatures, does say this meeting is being held under the authority of the Virginia Gas and Oil Act and cites the act, as well as the board regulations and the Virginia APA. So Diversified has been on notice of that. In regard to the matters of fact and law asserted, I find it difficult to believe that parties in this case are blind as to what the other party is going to argue in this formal hearing. There have been, first of all, the petitions that have been submitted to the board as well as proposed order contain a multitude of facts and matters that both parties are going to present during this formal hearing. In addition, regarding any other, extraneous issues, all of those have been laid out previously in other filings that both parties have been well aware of, and that I believe Mr. Street, even in his motion to request subpoenas, had referenced previous issues that that Diversified thought were going to be relevant in the coming proceedings that had to do with those previous filings. So I think everyone here is on notice of the matters of fact and law asserted. I think there has been sufficient notice of the issues. The petitions themselves contained the matters of fact and law asserted, needed to give reasonable notice in this case. And then we have all of the previous filings as well. So if I don't see any issue with notice here for the board, but I'll hand it over to you, Mr. Chairman.
Thank you, Ms. Cooper. Are there other questions from the board on this motion to continue that we need to discuss? We need to have further discussion? Or do we have a motion from someone on the board to either move forward with the formal hearings or to continue?
Talking about all of them.
Yes.
Including,
Well, we'll end up continuing 5 in reality, so we made that decision already.
but you're talking about also
Move on with
7, 8, 9.
Correct.
They want formal hearings. We don't have any choice, do we?
But we're already scheduled for the formal hearings today.
Just carrying it.
So what we're addressing today is their motion for another continuance, or do we want to move forward?
Is there any reason they can't be heard today?
None that I know of, no.
Because we've continued these from October.
Correct. They've been continued twice already.
Yeah.
Mr. Harris, you still with us?
Yes, I am.
Sure,
I'm
Rob's still
listening.
here.
It can't, I would submit there is a reason to continue, and that's so we can get all these records, review them, and get prepared for the hearing. That's,
Speak up a second, give you an update. It appears that our FOIA officer in our Richmond office has sent the documents to Mrs. Hesse at your office, since she was the requester. She sent them back to her, and I just emailed you all a copy of the document that has the map in it that you wanted to look at. That might help you a little.
Further discussion from the board on the motion.
I just have a concern that this thing has been going on since October. You know, we keep continuing and it seems that next month, all these are going to be continued, you know, again. So if that's our only option, then I don't, you know, but it seems to me that we're taking up an awful lot of time continuing these.
I know that Mr. Schwartz said we've continued these several times. That it was continued the first time because the board appointed a hearing officer. So that was the first one. And then the second time it got continued, it was continued because we didn't have the FOIA documents yet. And we don't have the FOIA documents today. So again, I'm not pointing fingers or blaming, but that's just a fact. We don't have the same documents we didn't have in November, we don't have now. So that's not our fault. And I know we all have a difference on how we see facts and law in this case, and that's okay. I know we advocate for our positions and I respect that. It's not personal at all. But if we're going to get to a fair result, and we can all agree that the process, in order to make the process fair, we need as much information as we can and to give us a chance to review the information and evaluate it and see if it helps us or hurts us or if it would help the board reach a better decision. Isn't that what we want to do, is to make the process fair? And if we thought in November, the process would be fair by us getting these documents, what has changed? We don't have them yet. Remember, most of these units will not be mined for 3 years. So.
Yeah, Mr. Chairman, I do have one thing to say. You need to check your mail, probably got what you are looking for. That spreadsheet, and other information on the wells, you probably got that in your inbox.
Okay, I'm confused. I thought you said it was just email.
Back to your office, it says your
Okay, when?
today.
Today.
Right.
Okay.
You know, we keep coming back and forth here. I mean, we have been, I think some of these cases were filed in July. You know, we've spent a tremendous amount of time on these cases. I mean, Jessica's absolutely right. I mean, if we don't know what our position is and what the other party's position is by this time, we're never going to know. And so in terms of notice or being aware and having a fair hearing and being aware of what the other party is likely to say or do during a hearing, we're all over that. And, I mean, there's no question about it. The question then is, are any of the outstanding FOIA requests, because they got a ton of information or direction from the FOIA answers. The question then is there anything outstanding from FOIA that we need to go forward today? And I don't think there is, and I don't think there's an indication that there is. The conversion of wells has nothing to do with the pooling applications. You know, there's just nothing that they don't have in hand at the moment that is relevant to a pooling application. We should be ready to go. We've been at this for a long time. We need to make some progress and be done. And hopefully that's today. And I will also say that I think, you know, the lawyers need to stop talking here. I'm only responding because Mr. Street had something to say. I think the board needs to do what it's going to do.
I haven't been able to look at my emails today, but I do know this. Whatever was out there, it cost us $2,000 to get it. I'm guessing that was more than just a little bit of stuff. I mean, we paid $2,000 for these documents. And we were under the impression we would get these before a hearing. And I just don't think it's too much to ask for us to get what we were told we would get timely, that we paid that money.
But do you think you'll be prepared in February without any reason to ask for a continuance?
As I expect we will, yes, ma'am.
Given the hour that we're at today, it's probably unlikely we would get through all of these applications.
Not today.
I mean, I don't know that we'll get through them all next month either, but is there a downside to starting today? That we can. You're not gonna render a decision based on anything that we have started today. We're gonna do the same process we did last time. We're gonna present, cross-examine, respond.
Yeah.
We're gonna go through all of them. We're gonna adjourn. We're gonna seek counsel. We're gonna write a written decision, and we're gonna come back next month or the month after with a decision. Does delaying it, I think there's gonna be ample time to hear any of those arguments. Unless you really think you're gonna get through all these today.
No, I don't think we will, but the concern is, I know
there'll be.
We don't know what's in the documents, we don't. And so a really big part of our position, really big part of our case, just like last time, is the way the orders work as a single consolidated system where a longwall panel comes through and a frac well is converted to a gob well, and the same operator.
I still have a problem with that terminology. You're saying we're converting wells to gob wells, and I don't think that's what's happening.
That may be the wrong way to say it. I don't know. I'm just letting you know. And you're probably going to disagree, but I believe, well, the important thing is that is our position, and there is language in the orders. So we have a bona fide legitimate argument that y'all may not accept. I get that. But in order to evaluate that and present that and cross-examine witnesses, I can't anticipate what that's going to look like today. And without the records, I don't know if it will hurt us. All I know is we did everything we could to get them, including paying $2,000. And you're right, we're not going to get done today. But if we're not going to get done today and we're going to do it later, why not do it later so we can get the documents? We'll still be in the same spot at the end of the program.
I'm not, again, I prefer to get started today. That's my position with the board. If we want to, we've heard enough discussion here. We just need to make a motion one way or the other, and the board can move forward from there. Anybody's willing to make a motion. If we don't make a motion and it dies, then we'll move forward either way. Is that correct?
Correct.
Ms. Cooper, if we don't get a motion, if we don't make a motion, if we don't make a motion on their motion to dismiss, does it die without a action by the board?
For the motion to dismiss or the motion to continue?
The motion
to continue. Okay. I believe the board still needs to vote either way.
Okay, so we need a motion.
Either way, the board needs a motion, and let me look into what happened if there was a tie. I'll look into that.
I think historically, and this may not be correct, and I think that's what Mr. Jansen is referring to. Historically, I think the chairman of this board have said the motion fail, or the petition fails for lack of a motion. So I think what Mr. Jansen's referring to is in the past, if nobody on the board makes a motion one way or the other, the request just dies. I think, correct me if I'm wrong, I think that's probably what you're talking about.
We're gonna have a motion.
I'd like to make a motion that we start covering these other cases.
So we have a motion to dismiss the petition to continue. Do we have a second?
I'll second.
You poll the board, Ms. Gilmer?
Owens,
Abstain.
Mr. Sutherland,
Yes.
Mrs. Gibson,
Yes.
Mr. Cochran,
Going to stay.
Mr. Harris,
Yes.
Mr. Mullins,
Abstain.
and Mr. Jansen.
Yes. So that motion is dismissed and we're going to continue with the hearings. We're going to take a break right now to maybe more than a half hour. That gives us some time to review the document. Half hour or 45 minutes.
How about 45 so we can find some food?
All right, we'll reconvene at 1:45.
All right, thank you.
Did you say 125 or 145?
Okay, everybody, I appreciate your patience. That was a little longer recess than we anticipated, but my understanding that the parties involved in the applications on items 5 through 10 have come to a framework of a agreement to move forward. And based on those discussions, the board's going to entertain a motion today to continue items 5 through 10 to the February hearing. In the event, give you a little more background on it, that these issues will mostly be withdrawn. The competing applications will be withdrawn, and we will only need to deal with parties who are not subject to this agreement. That's probably only with Unit F-36, if I understand correctly in there. So with that being said, I'll make the motion that we continue hearings on items 5 through 10 until the February meeting. Do I have a second?
Second.
Have a motion and second. Ms. Gilmore, will you poll the board, please?
Abstain.
Mr. Sutherland,
Yes.
Mrs. Gibson,
Yes.
Mr. Cochran.
Yes.
Mr. Harris,
Yes.
Mr. Mullins,
Abstain.
Mr. Jansen.
Yes. This time we'll continue those items until the February hearing. Other business between Diversified or Pocahontas or Buchanan Energy that we need to address today. Okay.
Thank you, Mr. Chairman.
Thank you.
Okay. Next item on the agenda for today is the board will receive an update from the division activities from the staff.
We don't have any.
No updates today from the staff. The final item is the board will review the December 2025 minutes for approval. Everyone's
Excuse
provided. Go ahead.
Excuse me, Mr. Chairman, apologies for interrupting. I believe that previously on January 13th, 2026, Council for Diversified submitted a letter to the board requesting to be heard on their unit operator update. And we need to see if, well, given that it did not meet the 30-day deadline prior to a scheduled meeting, if it could be continued to next month's docket as well.
Could you repeat that?
And
We had a
Mr.
lot of background going on in here, Ms. Cooper. What was that regarding?
It was regarding Diversified's January 13th, 2026 letter to the board regarding its unit operator transfer. Does that ring a bell, Mr. Street?
Yeah,
Your
Okay.
transfer.
I didn't hear the question though, but
Okay.
Oh,
Is there-
yes. Since it was filed less than 30 days in advance of a board meeting and it's essentially new business coming up before the board again, your position on it being carried over to the February meeting as well.
So if I understand it correctly, the documents have been submitted for the transfer to occur and it's under review by the staff at this time. Do we have an update on that review, Ms. Gilmer, where we stand?
Hearing the notifications. And last week we received another big bunch of notifications. So, I have to work on those. But I wasn't under the impression that it was gonna come back before the board, since the board's already approved it. We're just waiting on the notifications to be reviewed, and then the order is ready to go. Jessica has already prepared the order. But do we need to put it back on the docket? Because I have already approved it in our minutes. I'll have to.
Was approved subject to the notification, correct?
It was approved subject to an affidavit.
Right.
We've actually submitted 2 affidavits because we went back and gave some more notice. And I don't know that we need it on the docket, but there is one thing you may want to do. And the new notices we set for today. So you may just want to call the room to see if anyone appeared. That way you've got a record of, I don't think anyone has, but you'll have a record that way of that no one was here.
Yeah.
You know what I'm saying?
Yeah, I'm not sure what the board needs to do as far as a motion, Ms. Cooper, to facilitate getting that transfer completed, other than the staff's work that needs to be completed.
I just have a comment. Mr. Street submitted a proposed order with his January 13th letter. And the very last paragraph of that simply says that the board is appointing Diversified as operator and terminating, I guess it was Summit as operator. As long as that order gets entered, we don't have a problem with that. If there's other language about rights or anything else, we would have a problem. But the order that he submitted that simply says, we're not the board's operator, Summit no longer is, we're good with that.
Yeah.
Assuming the notices are good with the division.
Ms. Cooper, did you have, I know you've seen the format of that order. I think you had your own format of how that order should be. Does that need to be resolved by something with the board to approve that order? Or is that, which order are we going to end up recording once the notices issue is resolved? Does that make sense?
Mr. Chairman, was that directed at me? I just lost audio for the last minute. I'm sorry.
Yeah, it was.
I lost all audio. I messaged Ms. Gilmer. Can you please rephrase the question?
Yeah, so I think what we're talking about here is Diversified had submitted a proposed order to be recorded. It's my understanding that you had also worked out a template of an order for transfers that you had provided to the staff.
Yes, that was an existing template order that I just took another look at. I don't think I changed much of anything, maybe formatting.
So the question is the order that Diversified has submitted in January, does that need to be considered, or are we going to use the order that we already have on file?
She lost you again.
Oh, it's lost again.
If I could see the order that Jessica prepared or that Sarah has in hand, I could maybe just take a moment and if it says what Street's order says, I'm good with it. I just don't know.
I don't know either. I don't know that I've seen the other order.
Mr. Swartz, a copy if you're okay with that.
Yeah.
I was just assuming we would use the order that Jessica prepared.
Right. Do you have a problem with the order that, do you need to see it too? Have you seen it, or?
I've not seen it, but we just sent ours because we were just trying to
Tell me.
process.
It's just, it was a massive amount of notifications.
We did too much notice, didn't we?
Yes, and I was starting to see the light at the end of the tunnel. The first set, it's like 299 pages maybe or something. And then last week, you blessed me with another set. The problem with the first set, nothing was in order, nothing was in alphabetical order, no order whatsoever. That's what's taking me so long. I'm making a lot of progress on it though, finally.
Don't worry, I understand.
So just if you'll be patient with me, because I still have to do my regular normal work, but I'm trying to get to it. And I've been working late,
That's okay.
trying to get it.
Okay.
But then last week, got the new set. But it looks like it's in a little bit better order, so. I don't know when it'll be, but as soon as I can get it together.
So you back with us, Ms. Cooper?
Yes, I am.
Are you back where we at? We have two different orders, I guess.
Which
Um,
one? Was that the
Which
question?
one are we using? I guess is the question. And does that need to come back in front of the board?
If the
before it's
proposed
recorded?
order is the order that the board previously approved and reviewed, that one can be used.
Okay.
So I think the
Does-
board did previously look at it. If I remember
Okay.
correctly.
So does the order that Mr. Street provided in January, does it need to be withdrawn or anything need to happen or just ignore it? Or what are we doing with it?
If the board previously approved that order would be the one that would be entered.
Okay, so the one that, the January one doesn't need any action. Is that, I wasn't sure what your question was to begin with, so we're sort of circling around here.
I guess I think the parties should see the board's order. And I guess neither Mr. Street nor I have seen it. I mean, it could take a moment, but I think, wouldn't you like to see it, Ben?
Yeah, I probably would. What I was going to suggest this, if you're okay with our order and we're okay with our order, then if Jessica's okay with our order, we could use that one. If
I
Jessica,
agree.
if you're not okay with the order that Mark and I are okay with, send us your order. Mark and I will look at that and I suspect that will be fine. We just need to eyeball it.
Works for me.
She said she loves Scotty and again. Gonna try to join by phone.
Welcome to the audio conference.
There she is.
Can you all hear me now?
Yes.
Okay, thank you. I'm calling in so that we don't keep having me dropping out. Apologies. What, can we please have a restatement of the last question directed towards me?
So I think the issue that we're trying to decide here, whether the board needs to take an action on is we have two orders addressing the transfer of operatorship from Diversified from Summit Appalachia. We have the one you prepared and we have the one that Mr. Street has submitted in January to help facilitate this matter. Neither Mr. Schwartz nor Mr. Street have seen your proposed order. And they've agreed that if you'll provide that order to them and they don't have any problems with it, that's the one that can be recorded and we'll not use the one that Mr. Street submitted. Does that make sense?
Okay. Okay, yes. And just to clarify, the one that I had edited in the past was a form of like a template order, not particularly for this case. I'm happy to coordinate that going to Mr. Street and Mr. Schwartz for them to look at. But in this case, we could still use Diversified's order. But if parties wish to see that template order, I'm happy to pass that along.
I think Ben and I have agreed to use his order. Then you don't have to fool around with that.
Okay.
Correct?
Correct.
Ben?
Okay.
Okay.
So then the question is, does the board need to review that order again that's different from the one that we were provided on the original hearing? Does the board need to do anything or?
If it's different than the one the board has previously seen, but correct me if I'm wrong, Mr. Street, but I believe it should be the same order as was originally provided to the board. I don't think it will be different.
Well,
I would like to say I agree, but I'm not sure I do because I don't think we ever, if the board looked at an order, that didn't happen in a meeting that I attended. So I can't speak to that, but here's what I would suggest. Jessica, you look at the order that I presented. If you're okay with it, Mark's okay with it, I'm okay with it. You can call the chairman and you can tell him that you approve it. And then if he says, okay, y'all can just sign it.
That's the order that'll get recorded.
That's the way you normally do orders, I think, but I'm not sure.
Yeah, again, that process is we have the hearing and an order at the same time, and we're basically approving at the same time. But if that order changes, then we have not ever seen it. I don't know. I can't remember if one was actually provided during the original hearing or not.
I think it was.
Good.
Okay. So we've never looked at it anyway. It's just a template. Okay. I think we can resolve this. If not, we'll let everybody know it's going to be on the docket next month if we need to have it.
One thing you can do, one thing that I do when I'm in these situations on other boards is we will have a motion to enter an order subject to the approval of our attorney. And then if she approves it, you have the authority to go ahead and sign it.
Does that work for you, Ms. Cooper?
Yes, sir.
Okay. The board heard the motion. Do I need to restate it, or does someone want to make that motion? I'll restate it, if it makes it clear for everybody.
I'll make a motion.
So the motion is that the board will, say it again how you said it.
The board may want to entertain a motion to enter the order that has been reviewed and approved by Mr. Schwartz on behalf of Pocahontas Gas and Mr. Street on behalf of Diversified, subject to the review and approval of Ms. Cooper.
Do I have someone who will make that motion?
I'll make,
Do you have a second?
Second.
All those in favor say aye. Aye. Any opposed?
Aye.
Any abstain? I think there's any vote. So we're good to go there. Okay, does that resolve that? Adequate, Jessica?
Yes.
Yes, sir.
Okay, thank you. The final item on the agenda we were getting to was the board review the 2025 minutes for approval. So I have a motion to approve those minutes.
Motion approved.
Do I have a second? The motion is second. Everyone in favor, please say aye.
Aye.
Aye. Any opposed?
Aye.
It's approved. This concludes the meeting of the January 20th Virginia Gas and Oil Board hearing. Thank you, everyone.